May I now request Honorable Mr. Justice K.V. Viswanathan, Judge of the Supreme Court of India, to grace the gathering.
My very distinguished brother and friend, Justice Manmohan, Justice Pratibha Singh, Mr. C.S. Vaidyanathan, distinguished senior lawyer, distinguished judges of the Delhi High Court, the President of the High Court Bar, the bridegroom of the evening, Adarsh, ladies and gentlemen, a very good evening to you. This function was really to be held last Wednesday, that is the 4th of December. But we suddenly realized that there was a mistake in the complete specification on the invitation card. Justice Manmohan, who was by then a judge designate of the Supreme Court of India, when the cards were printed, he was the Chief Justice of the Delhi High Court. So, Adarsh Ramanujan unwittingly committed a patent error. Friends, if you compare the statistics with Justice Manmohan so felicitously reeled out about the figures released by WIPO and contrast it with the statement of course, wrongly attributed to Charles Holland Duell, who in 1897 is supposed to have said, "Everything that can be invented has been invented. Let us close the patent office." But whoever said it, if at all it was said, has been proved utterly wrong by our author, Adarsh, who with his lucid writing style has encapsulated the growth of patent law across jurisdictions in the past century. What was fascinating about this book, which is, I had occasion to read them, I can't say I studied them, is that it is neatly divided into 21 chapters and deals with the abstract concepts, very, which belongs to the patent law in very simple language, in a manner that is easily comprehensible. But I was pleasantly surprised to read that even an abstract subject like the patent law could be made interesting by the patent bench in the bar, if only they have the sense of humor to do that. Now, savor this. This is from a Fed shrift for the famous IP judge, a former judge, Robin Jacob. It records a remark made by Lord Neuberger, who was then the Master of the Rolls. Speaking on the retirement of Right Honorable Lord Justice Robin Jacob, he said, quotation, "In the Court of Appeal, Robin ran the IP appeals list brilliantly. He even lets me sit on the occasional appeal. I was a bit mystified why I was sitting on an appeal a few weeks ago which involved machinery that makes lavatory rolls and kitchen towel rolls. I only realized during the course of the first morning that of course he decided I should hear it because my job then was the master of the rolls," he said. But on a more serious note, I'll just deal with 3-4 aspects of the book which really fascinated me. The author is a strong votary of the patent bargain theory that lies at the foundation of patent law, namely incentivizing the patentee by granting a temporary exclusivity on a bargain that the public would be made knowledgeable about the means of producing the invention after the expiry of the grant. The author draws copious support from the Justice Iyengar Committee report to bring home his point. The author clarifies that the Justice Iyengar Committee expanded on the patent bargain theory by adding the working of invention by the patentee as a further element of the bargain, so that he doesn't idle after obtaining the patent. That underlying theory sets the stage for the author's further deliberations in the book. Thereafter, you will find with chilling clarity the author analyzes the metamorphosis of the patent law from the 1911 Act to the amendments of 50, right till the 1970 Act, with all the 4 amendments of 99, 2002, 2004, and 2005. There was one interesting area which I want to mention, and I want to also to float an idea from yours truly, a wholly indigenous one. I floated this in the Indo-Singapore Judges Conference, and it was not met with either resistance or laughter, so you'll bear with me if I try and advance it before the IP bar here. The author deals with the advent of artificial intelligence and its interplay with patent law. There's a fascinating discussion in the book. All of you are broadly familiar. There is a predominant view that it should not be granted, and USA, UK, New Zealand, and Australia are arraigned on one side, with South Africa being the outlier. The author highlights the view of the original court in Australia, since overruled, that AI inventorship would incentivize innovation in this space and promote disclosure, which was a better option than pushing the owners of such AI systems to maintain secrecy over the same. Now, this is my addition now. A question does arise. Should the baby be thrown out with the bathwater, or could there be any other arrangement to encourage AI inventions? If not an entry in the patent register, should AI inventions backed by an appropriate statutory regime be entered in a separate register, with the first registrant having certain exclusive rights? So, if anyone with the process of reverse engineering would copy it, he would have to either submit to a license or submit to the payment of royalty to the first registrant, so that even if you don't want them to come into the patent register, I think it's an aspect which we need to explore, because I read from Kissinger's book on artificial intelligence that when the Harvard Medical School set about to invent an antibiotic called halicin, it appears that if it were done through the manual process, it would have taken innumerable number of hours and cost them humongous amounts of money. But with AI, they did hit upon the molecule, which was ultimately named halicin. So I don't think that AI should be outrightly rejected. It calls for a certain amount of thought before we take a final call on it. There is a fascinating discussion on how the Indian courts have heavily borrowed from the case law of the foreign jurisdiction. The author is careful to lodge a caveat that such case law from overseas cannot be used to override the legislative intent of Indian Parliament. As you know, there's been a raging debate across the world as to whether at all case law of foreign jurisdiction in any branch should be interpolated into the domestic one. On the one hand, you have Lord Bingham, who welcomes light from all sources like our author. But at the other end of the spectrum are the likes of Justice Scalia, who have been ruthless in castigating foreign judgments as meaningless dicta and ruled that courts should not impose foreign moods, fads or fashions on Americans. But I think we should welcome light from all sources and adapt it to our conditions. 3 full chapters with a separate introductory chapter have been devoted by the author to discuss non-patentable subject matter. The author clears the deck by rightly commencing his discussion by stating that the subject matters which would retard progress and where there are overriding public policy concerns ought to be categorized as non-patentable. Thereafter, exclusions relating to pharmaceuticals, biotechnology, and software business methods have been addressed. The author copiously discusses case law, but he doesn't stop just with referencing them. He is prepared to critically analyze them, and I think that's a great quality for an author, and I congratulate you for that. He doesn't fight shy to call a spade, and if there is a Supreme Court judgment which he feels was wrong, with using his liberty as an academic, he is able to give reasons as to why he thinks it is wrong. The subject of standard essential patents, a subject which is very favorite to Justice Manmohan. We were on a panel and I had copiously referred to his judgment on that while addressing the gathering. Earns a separate chapter considering its importance. In the end analysis, a technical and abstract subject infested with jargon has been made easily comprehensible. There's no doubt that this book will be an useful addition to the library of the members of the legal fraternity, students of law, persons concerned with business and industry, and all those who are in any manner associated with intellectual property law. I wish the book all success and many more books to your pen. When I entered, you introduced your family and Dharma. I didn't disclose it then. A book to an author is like a child. So Dharma has had another sister. So all the best to you, and I wish you keep writing, and it's fantastic that you, in spite of your busy schedule, found time to sit and write and share your knowledge, because this is a cutting-edge topic, as was rightly mentioned by Justice Manmohan, and books like this will be of immense help, particularly to the members of the IP bar, but more importantly for the younger members who are trying to gain expertise, and of course for those involved with the administration of justice. Thank you for inviting me. I deem it a privilege to release a book by a young author on an important area of law. I wish you all success. Thank you very much.